Hi, this is Attorney Mike Griffin coming to you from Chicago as usual, and today we got a pretty serious one. It's the Waukesha parade case. I've gotten a lot of requests to react to the defendant being allowed to represent himself. Let's do it.
Something to the effect that it was their opinion that Mr. Brooks reasonably understood with reasonable accuracy why the evaluators were there, the limitations of the confidentiality associated with that even during those evaluations, if he was being difficult, that he was nonetheless able to communicate with them. He was articulate. His remarks were coherent, fluid, at times, though, they were avoidant of questions asked. I would say this, my observations of Mr. Brooks and perception over the course of the proceedings throughout this case is strikingly similar to some of the commentary and observations by the evaluators, including even the angry outbursts that we've seen in court, the avoidance of his responses to questions asked.
I object to that because at the end of the day,
I understand, Mr. Brooks, stop. You can object. Your objection is noted. I'm going on. This is one of the expectations that I have, is you can object. It will be noted, but you can't keep interrupting. I need to have an accurate record.
Okay.
So
Okay, so this is really interesting. The judge is giving a ruling. They did a FREDA canvas of the defendant, and they had an evaluation, and they said that, you know, there's no reason why he can't represent himself. Now, of course, he's going to do a horrible job. None of this really much matters, I don't think, given the weight of the evidence here and the horrific crimes involved. I think he's going to be convicted.
Your objection, sir, your objection is noted.
Something that I haven't been privileged to read myself.
This is a prime example of some of the difficulty with Mr. Brooks.
I don't think you have a PhD, Your Honor.
He can be, in my opinion, deliberately disruptive.
I agree with the defendant here. I don't believe the judge has a PhD. Now, I don't know, but most don't. They do have JDs, however.
But nonetheless, he maintains being competent at the most basic level in order to present the defense on his behalf.
Object to that.
He's objecting to her ruling that he's competent at the most basic level. Okay.
I talked earlier about some of the case law, or at least referenced it, and I want to start with that, or I should say, start my decision, my ultimate decision at this point with the case law. The Sixth Amendment guarantees a mentally competent defendant the right to represent himself in a criminal trial, no matter how foolish that choice may seem. This is a quote from Beretta versus California, found at 422 U.S. 806. The quote is from Imani versus Pollard, and the court in that case went on to say the following: the constitutional right, quote, exists to affirm the dignity and autonomy of the accused and to allow the presentation of what may, at least occasionally, be the accused's best possible defense. That's Imani versus Pollard, quoting the McCaskill case. A judge may not deny a competent defendant's timely invocation of his right. Under Ferretta, a defendant's reason for choosing to represent himself is immaterial. Defending pro se will almost always be foolish, but the defendant has the right to make that choice for better or for worse.
Pro per.
In Wisconsin, just like in...
Okay, so now he's arguing with the language used in the Ferretta case that she is reading right here. He's saying pro per instead of pro se.
Ferretta, the court recognizes his right to represent himself. What this court needs to determine is whether Mr. Brooks is making a decision competently, freely, voluntarily, what we refer to in the case law as a knowing and voluntary waiver. That is why the court went through the advisement of the charges, the penalties that Mr. Brooks faces, why it gave Mr. Brooks form CR 226 and went through that with all of the advisements here today. That's also why the court went through the advantages of having an attorney and the disadvantages and challenges of being one's own attorney and representing oneself. I believe that the record demonstrates this court has warned Mr. Brooks about what he is getting into, the challenges, or at least some of the challenges that he may face, including on topics such as jury selection, trial objections, rules of procedure, etc. In the words of Imani versus Pollard, what this court needs to do is make sure the defendant makes the choice with eyes wide open. And that's quoting Iowa versus Tovar.
This is really interesting to me. It's never come up in over 25 years of practice for me because I simply am not engaged in any litigation where you have non-attorneys involved. I just am not in terms of what I do. So I've never seen this stuff come up, and it's fascinating. She's making a record, and she's gone back through the case law, and she wants a good, clean record of this. So she did research, or had clerks do research for her, and read all up on all this stuff before she made this ruling.
I have made Mr. Brooks aware of the dangers and disadvantages of self-representation by going through not only this form, but by reviewing with him once again the charges, the penalties, the exposure that he faces. Ultimately, in the end, a competent defendant has a constitutional right to represent himself, even if the judge or anyone else thinks there may be no good reason for him to do so. I'm not saying you don't have a reason, sir. I'm frankly speaking to your mom at this point. He may not understand. Understanding is not material. You have the constitutional right to make this choice. What's important for this court, and why I also went through some of the other biographical information, is you have a high school education. You've completed the 11th grade. You have an HSED. You are clearly literate. You've been able to communicate with the court efficiently and effectively. At times, you press the court when there is something you don't understand or believe is not going your way. But to me, that's a sign that you understand and are advocating on your behalf. Frankly, statements like, I'm informed or I'm aware are the functional equivalent of you saying, I understand. I cannot say that this is one of those narrow class of Mr. Brooks.
I object, which is my First Amendment right to be able to say what I want.
Mr. Brooks, your rights do not involve interrupting me. That's the,
I objected. I didn't interrupt.
The procedure that we will follow. At trial, what's going to happen if you continue to do that is you will be admonished in front of the jury.
That's fine.
If you continue that.
That's fine.
Like I said.
That's almost comical. The judge is doing a great job. I like her approach. She's being very careful about this, but the expectation that he cares about being admonished is optimistic at best.
This is not one of the narrow class of cases in which a defendant may not be competent to represent himself because there's no evidence before the court to suggest he has a severe mental illness, which is why, of course, I looked at the NGI evaluations, because that is competent, recent information before this court regarding his mental status and his understanding of what is going on.
That has no relevancy to
this
why
court
we're here
has
today.
been able to render the following. It is this court's opinion in finding today that Mr. Brooks understands with reasonable accuracy and is aware of the difficulties and disadvantages of self-representation, the seriousness of the charges against him, as well as the general range of penalties, and that he is making a deliberate choice today to waive his right to an attorney and proceed without counsel. This court further finds that Mr. Brooks is competent to proceed, whether he refers to that pro per, pro se, or simply self-represented. He reads, he writes, he understands the English language. He's been able to communicate with the court. He has no physical or psychological disability that impacts his ability to communicate with the court or to communicate a defense to the jury on his behalf. I've not been able to find on the record, and he has not advised the court of any disability, physical or psychological or otherwise, that would affect his ability to communicate with the court or to a jury. In the words of Pickens, Mr. Brooks has the minimal competence necessary to conduct his own defense. I'll further find that he understands the proceedings, the nature and seriousness of the charge, the maximum penalties that can be imposed if convicted of these offenses. He understands that a lawyer may be of assistance, understands that a lawyer may be appointed if the defendant is indigent, and understands the disadvantages of self-representation.
Never once said I understand.
He is voluntarily and freely waiving the right to be represented by counsel and is making a deliberate choice to proceed without counsel, and therefore the court will grant the motion to withdraw brought by Attorney Perry and Attorney Keyes, and from this point forward, Mr. Brooks will proceed as his own attorney. Does the Public Defender's Office require any type of written order discharging?
No.
All right. The minutes on CCAP will be sufficient. All right. If there is.
Okay, so I wasn't aware of that. I was wondering who was sitting at counsel table with him. So he's currently represented. She just discharges him right there and says, "Fine, you can proceed pro se." It's interesting that he keeps saying he doesn't understand, and all he's doing is try to delay and get attention. It's just annoying knowing the background of the case. It's his last bit of attention, but we have a constitution. It means something, and you have to follow it.
The need just simply file an order under the local rule, and I'll certainly review it and sign if appropriate.
Thank you.
Anything else you need from me today before I continue with this hearing?
From us?
No, from Attorney Perry and Attorney Keyes.
From us, no.
All right, you may, you are discharged and certainly are excused from the remainder of this hearing.
Governor, can I just clarify, as to the discovery, Attorney Perry, you indicated all paper discovery have been turned over, but not the electronic discovery, correct?
Not turned over, but it will be, we'll make arrangements with the jail.
You're going to turn over the electronic discovery? Yeah. Okay. Very good. Thank you.
I find it interesting also, it doesn't appear that he has standby counsel, which I would expect. Again, I don't do this, but from watching trials recently, I would expect them to appoint standby counsel. But apparently they're just letting him go by himself, which is fine. They certainly taken their time in the decisions they're making. When I say they, I guess I'm really referring to the judge here.
All right, I know we have a number of outstanding issues. That documentation was provided to Mr. Brooks at the close of the hearing yesterday. Mr. Brooks, are you in a position to respond to that so that the court can address those outstanding issues today?
What are the outstanding issues?
Those are the documents that I gave you yesterday.
The ones that I already had?
I don't know whether you had them or not, but I specifically gave you all of the pleadings that had been filed from the motion to withdraw forward. That was provided to you yesterday.
So what are the issues?
Are you prepared to address them today, sir?
What
You
are-
have two options, sir. We either address them right now, or I have to come back yet before the trial or decide all of them on the morning of trial, and I'd rather not do that.
That might be the way to go because I don't know what issues you're referring to.
So you see his strategy here is just do the most irritating thing possible.
So you didn't read any of the paperwork that I gave you?
I think Your Honor, that you should understand my position in the jail.
Well, there you have it. He's going to be representing himself. I'm sure he won't do a good job. I'm also quite certain that it won't make much difference. I haven't seen it. I haven't seen the evidence. You have to go through the process. I'm not suggesting you don't, but I think that there's going to be a lot of evidence. I don't think even competent counsel could do much with it. What he is going to do is delay and distract and annoy, and ultimately get convicted, if I had to guess. And that's where we are. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.